We will continue to look at the need for us to solve the issues of man. Well, the day man is born, basically that's where his troubles starts. And looking at the need for us to continue to interrogate the process as regards the program law and you, I want to say welcome on board with me on a topic that we discussed earlier, but we're going to be expanding on it. My name is Philip Omo-Gyukpo. We're going to be looking at the dispensation of electoral justice and the role of the judiciary. And joining me to discuss this is Emmanuel Obakbolo, a legal practitioner. Big thanks for joining me.
Good afternoon, Philip. Good afternoon, Nigerians.
Well, Nigeria is in search for dispensation of electoral justice. We keep saying issues as regards the judgments delivered by courts, though contradictory sometimes, but the big question that pops up is, can the judiciary, under the present leadership of Ahmed Bola Tinubu, really dispense electoral justice? But before that, let's look at the meaning of electoral justice, Emmanuel.
Yes, electoral justice is the delivery of judgment in consonance with the provisions of the law and also the precedents of the courts as judgment delivered by a higher court, which today in Nigeria is the Supreme Court of Nigeria. The precedent laid down. Okay. So that is electoral justice. Okay. And we've seen before now that the courts in Nigeria has followed that precedent judiciously and judicially. And they've also followed it religiously and judiciously, as the case may be.
Okay, what are the key responsibilities of the judiciary in making sure that there is free and fair elections, credible elections? What do you see as the key functions or responsibilities of the judiciary?
The provisions, the responsibility of the judiciary is laid down in Section 6 of the Extant Constitution of the Federal Republic of Nigeria, wherein it is to interpret the law. And the law is interpreted in consonance with the facts and figures as presented before the courts. So you cannot just interpret the law where there are no facts to marry those laws with, or facts and figures to marry the laws with. And so where there are facts and figures, then those facts and figures must be married with the law as laid down in the provisions of the laws in Nigeria. That is, if we talk of the laws now, particularly the laws that regulate the elections in Nigeria, you talk of the Nigerian Constitution, you talk of the Electoral Act 2022 as amended, you talk of INEC regulation and guidance too. So these are some of the laws that regulate the election petition or electoral matters in Nigeria. So whatever is the facts and figures that you have, they must be married to these laws, the provisions of this law, so that you cannot have an electoral justice. Okay.
There is so much hue and cry, in every sector, basically looking at candidates of parties that seem to lost in the judgments of the court, where they say that they did not follow the dictates of democratic tenets. When can we say that the electoral justice has been delivered in our law courts?
Well, I think before now, when we used to have judicial activism, there were judgments of courts, particularly the higher courts, which is the apex court, the Supreme Court of Nigeria, where you see valid and sound judgments. And that is when, like I did say, we had judicial activism. But just now, I don't think we have that kind of legal minds that occupy the courts just now. Maybe if we do have them, we have just very few of them, and they may not be privileged, as the case may be, to be in a panel that delivers or that goes through the rigor of judicial processes in an electoral matters. So when you talk of justice, electoral justice, you also consider the panel, because it is the panel that will now state whether or not you have those who have the minds of judicial activism, who are ready to go through the legal process and follow the precedents as laid down by previous judgments or by the higher courts, and follow the stricto sensu. So when you have that kind of system, or you have that kind of process, or you have that kind of panel on ground, then you are home and dry, and you will not know that yes, you will have judicial a perfect electoral justice, as we have seen in the past. That's why when some persons accost me and begin to ask, why is it that the judiciary gives this kind of judgment, that kind of judgment, and today what we see in Nigeria? I say, look, there is no need to say we have this legal search for those who can really stand their ground and give judgment, particularly in electoral matters, the way it is or the way it ought to be, or in consonant with the laid down precedents and provisions of the law. We've had it before now, like in the case of Muhammadu Buhari and then President Musa Yar'Adua. We saw the Justice of the Supreme Court that dissented, Honorable Justice George Oguntade JSC, as he then was, where he stated, and I quote, that I will say the truth, even if the heavens will fall. Of course, when the truth is told, the heavens remain in place. He dissented in that judgment. And though Muhammadu Buhari lost, but his own part of the judgment favored Muhammadu Buhari as at that time. Okay. But today we see where all the justices will just followed a kind of a bandwagon, a traffic way of a judicial process. But I think we still have some sound legal mind, some sound legal judicial activism, wherein they can come up with and follow the laid down precedent by those before them. But again, like I did say, is who are the members of the panel?
Well, in case you're just coming across, the program is Law and You, and is brought to you courtesy of Noah Attorneys, a firm of legal practitioners that is in Benin City, Nigeria. And of course, you do well to pan out your questions to us. I mean, you can ask us your questions via the numbers writing on the screen, and that could also help us to form a new topic or look at areas where we can also satisfy your search on information as regards what you really want us to, analyze. My name is Philip Omo Gyukmon. We take a short break. Do stay. Good to have you join us. It's still Law and You, and I have the legal practitioner with me, Emmanuel Obakwalo. Let's look at the brighter side. But before that, there seems to be the challenge that the judiciary could be facing in Nigeria, because you made mention of the personalities. But again, can we say that the judiciary could be open to manipulation by the executive?
Yes, we've seen it in Nigeria. That is what is happening just now. Though there could be denial and counter-denial. But we've seen, under this dispensation particularly, we've seen where, with due respect to the decision of the court from the tribunal to the Supreme Court in the 2023 presidential election, though so many thoughts have come up with their own position, but the court came up with a different decision, and whether or not any person believes it or agrees with it, that becomes the law. And today that is the law, and that is why the person of Asiwaju Bola Ahmed Tinubu remains the president of the Federal Republic of Nigeria. And also we had other elections that have been conducted under this precedent, by state election, governorship elections, and we see a lot of hula baloo, a lot of shout, a lot of outcry with the decisions that came out from the courts. But then the decision of the courts remains, stands, and some legal minds have this thought that the due process of the law, the laid down precedents were not followed. And there is a diversion. And I think I'm one of those who hold that view, that there was a diversion from the laid down precedents of the law for reasons best known to those who came up with that decision, best known to the court or the tribunal, as the case may be. But I think we can keep trying again to ensure that our elections are not being determined by the courts. If INEC can sit up and be independent as its name reads or pronounced, INEC is actually independent and conducts an independent election without any fear or favor or interference, as the case may be, then there will be absolutely no need to go to the court.
Well, you may say that
the determination of who wins an election.
Yeah.
It is more dangerous for the court to determine who wins an election than for the electorate to determine who wins the election.
Well, you may say that, but I tell you, we live in a society where even if something righteous has been done, there must be a way to also tackle it from the other side. You know, in every coin you have two sides. And so, but let's look at, because by what you said, I could say maybe you are looking at a direction where, you know, mechanisms can be put in place that will prevent the bias, you know, or any external influence on judges that preside over election petitions. Now, do we have a constituted body in the judiciary that can act as a mechanism to prevent bias or external influence on judges?
I do not think so. Because just now what we have, though we have the National Judicial...
The NJC?
Yes, the NJC, National Judicial Council. We have the State Judicial Council, as the case may be. But when it comes to the pronouncement of courts, you have little or no case before them with respect to the arrival at a decision by the court, particularly when it has to do with election petition matters. Electoral matters are special matters. That's why you see some of us are still craving, some of us are still suggesting that there should be special courts for election petition matters. Okay. Maybe until we have that, we'll still be having these processes, this style, this outcry after the determination of election petition matters by the courts, wherein you hear people begin to say what is not and what is, as the case may be. But I want to tell you that where we have judges like yesteryears who will dare any person to their face and said, this is my decision, this is what I have arrived at, and this is what the law is, and this is what the law ought to be, and this is what the law will remain to be, and gives a sound judgment in consonance with the laid down procedures of the law, then we'll have less complaint. Okay. Because like you did opine, we live in a society where any atom of complaint, any atom of any process, there is bound to be complaint. But then again, when you look at it, that where the complaint is much, what is the veracity of that complaint? Who caused the complaint? And why is the complaint? I was in a seminar where somebody who was a guest speaker said, oh, the legal profession is under attack. And my question to him was, who is attacking the legal profession? And why is the legal profession under attack? Who caused the attack? Those of us, or those who feel that the profession is under attack, do not take time to look for the reasons why the profession is being attacked. But they are quick to say that the profession is under attack. Now, when you know that the profession is under attack, what remedy have you suggested to ensure that the profession is not under attack? So these are some of the factors, these are some of the issues that needed to be treated, that needed to be handled, so that we will have a near perfect judicial process. Okay. Again, I repeat, if the electoral process as laid down by INEC rules and guidance is followed stricto sensu, do you not think that there will be need to make recourse to the court for who determines the winner of an election? No, there won't be. Even where there is, it will make no sense to even go to the court to say you want to know. Then we will have a system where a loser can congratulate the winner of the election. But here, we do not have that kind of style now, because everybody feel that, oh, the court is the last stage of who wins, who determines who wins an election. And that is why you
or who determines the results of an election.
So, and it is
it's not the people that determine.
No, it is dramatic, and that's why I did say that it is dangerous for the court to determine the result of an election. I think the electorate are the one who ought to determine the results of an election.
Okay, let's look at it this way. Do you see gaps or challenges in the legal framework that guides election tribunals? Or how can we improve in the legal framework that will guide election tribunals that will make judgments to at least resemble justice in the electoral
when you look
aspect?
When you look at the Nigerian constitution, the extant constitution, I am of the view that the constitution has a lot of lacuna. I'm of that view. Also, the Electoral Act 2022 as amended has a lot of lacuna, despite the series of amendments conducted on that electoral act. That electoral act was given birth to by the Electoral Act of 2006. So if you look at it now, you now discover where there are a lot of lacunas in the constitution and the Electoral Act. Why is it then that we will not have a lot of lacuna in the determination of who wins an election, whether by the court or INEC?
Good question.
So now what do we do in that kind of situation is to ensure that the laws are properly placed. That which the law ought to be, it should be. So where the law is defective, the election itself and the determination of the election will be defective. And that's why we keep running back to the courts to determine who wins an election. So in other crimes, we've seen that elections are determined by the electorate. Yes, but just now some would argue that even the almighty United States of America, the now president of the United States of America, once upon a time went to court when he lost an election. Yes, he did that for reasons best known to him. And like I tell people, I said the present president of the United States of America is a black man in white skin, probably a Nigerian. And that is why you see that even after the election has been, the result of the election has been announced, as it were, then he went to court. And even when he lost, he condemned it. But now that he has won, he has praised the electoral system of his own country. So back home, if we can create a system that works, then there will be no need, absolutely, for the court to determine the results of an election. I think the court is under trial whenever the election is conducted in Nigeria, and the result of that election is brought before it to determine what the result is and who indeed won that election. So it is dangerous.
Well, thank you. Well, electoral integrity is actually what we're really gunning for, making sure that the electoral process in Nigeria is seen as having the toga of transparency and, of course, free and fair and credible. That's it. So let's look at how we can, speed up or improve on the efficiency of, resolving disputes in our law courts. Do you see ways in which that can be improved? Because sometimes they say justice delayed is justice denied. But I know there's a given time, a period for which electoral disputes can be resolved quickly. But is there a way one can improve its efficiency and, time factor?
Firstly, with my little experience in the practice of law, I've come to know that the delay in the determination of cases before court is not caused by the court. It's caused by we lawyers. And that is the chloroquine bitter truth.
No. Apart from that, there is also a time frame given. Like, in the general elections, for instance,
yes,
where we have a president-elect, and the space at which, the time frame at which the constitution gives, now gives room for the president to take his oath of office and then sit as the president, you know, before such cases get to the Supreme Court. Some have said this process can kill justice. This process can rob the electoral process of integrity, because by the time an oath of office is taken as the president, there's this toga of influence that is being peddled, that the president has, of course, and he wields huge powers that could also influence other organs of government. So how do we tackle this ugly menace?
I think we should borrow a leaf from Kenya. In Kenya, if my memory judges me correctly, it's 3 weeks upon the announcement of the winner of the election by the electoral.
3 weeks.
3 weeks. The president, the winner of that election, cannot be sworn in. He must wait upon the determination of who won the election by the court.
And it goes straight to
the Supreme Court.
The Supreme Court. Or so the Supreme Court delivers the judgment.
So the rigor of going through the tribunal, the appeal court, then the Supreme Court is not there in Kenya. So if we can borrow a leaf in this country,
but obviously 3 weeks can't be enough. Obviously 3 weeks can't be enough. Because you need to dig out evidence.
No,
you need to investigate reports, documents.
Where the electoral body is dutiful, where the electoral body carries out transparency, like the one we had where you say, okay, all the results will go through the RF.
Okay.
If the results did go through the RF, do you think there will be need to start looking at the BVAS machine, start counting electoral boxes? No, there will be no need for all of that.
All right.
So you will just go straight to it. So borrowing a leaf from Kenya, I think, is the ultimate solution to the determination of the legal process before the president, the elected president, is sworn in.
All right, thank you so much. Well, I'm afraid that time is no longer friendly for us at this point, because we need to really do the needful. And big thanks for taking our time to be part of this. We will continue to interrogate the process, and basically we have this topic that is really, really sensitive and demands your attention, of course, your contribution, your participatory, ability in order for us to forge ahead and extend the frontiers of this conversation. We're going to be having an opportunity to do this again sometime next week. I am Philip Omo Gupon. Goodbye.